Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. I am supposed to tell you to like, subscribe, comment down below, and share this video because when you do those things, it helps us to help more people just like you. Now, I've got all that stuff out of the way. Let's answer the question. We have a question from YouTube user Safety Buddy, and he and I were kind of commenting back and forth a little bit today. So I thought I'd make a video to kind of give a definitive answer because I thought, it was an interesting topic that might help some people. So Safety Buddy commented, who can be considered an accessory after the fact? Everyone within the company that knows, allowed, or committed the offenses against the plaintiff? And I responded, sounds like you might be using criminal law language in a civil law matter, if I understand you correctly. Safety Buddy said, yes, I believe that what has transpired and is still going on is both a civil and criminal matter. In fact, entirely possible. Certainly happens. Happens a lot of times in cases of like really aggressive sexual harassment and stuff like that. But it could happen. Listen, there's certainly hate crimes that occur that are criminal matters tied to workplace discrimination matters. We've seen that. This happens, right? You can have a criminal matter and a civil matter both tied to the same series of events running in parallel, but they're very different matters. And let's get into how and why. Safety Buddy goes on. Is there truly such a great divide between civil and criminal when both are obvious to have occurred? And then he goes on, I know there's someone who's having a terrible time getting the representation he needs. Safety Buddy, use the Find an Attorney playlist that we have. That'll help you, that person to pitch their case successfully to attorneys. Certainly. It's always, I hope it helps. But to answer your question, yes, there is a massive divide between civil and criminal court. Now, admittedly, in federal court, the same judges can handle a criminal matter and a civil matter. That is true. Generally, in state court, you're going to see different judges do it in most jurisdictions. Although even then, it depends on where you are and what's going on. And, there could be judges that handle both, right? But generally speaking, criminal court is a completely separate court outside of federal. The federal is different. But at the state level, criminal court is going to be separate from civil court. There's going to be different laws. In criminal court, the state or the government, whoever it is, the DA's office, are the ones bringing the case, right? And the person who's accused, the accused, is the one defending themselves, or hopefully they have counsel. You have different procedures. You need to prove different things. It is generally not the same in any way, right? I'll give you an example. If you have a workplace discrimination case that ended with a physical attack, right? I still just have to prove all the things tied to the workplace discrimination case. The physical attack in the civil case, which is what I handle, would be an evidentiary point where you can bring up and like, okay, here's the doctor's report, here's the contusions, here's the, this, that, here's what happened from the emergency room, here's the police report. It all produces evidence for the civil case, but for the civil case, I still have to prove a discriminatory animus, like this was motivated by my client's membership in a protected class and a negative workplace consequence, and we're pretty much there. That's what we had to prove to get that workplace discrimination claim rolling and potentially win, right? In a criminal case, you're going to have a bunch of different things you have to prove. And the state's going to have to prove, the district attorney's office is going to have to prove to put that person either behind bars or have them found guilty and have them face criminal penalties of some kind, whether that's anything from, public service to anger management, to incarceration, to fines, to restitution, whatever it is. There's all these different penalties. And also in criminal court, really notably, the victim generally doesn't win money. Now, I did say restitution, right? Like there's certainly situations where thieves or con artists end up trying, as part of their plea bargain or as part of their sentence, trying to pay restitution. So I'm not saying there can't be some money that changes hands, but I'm saying, generally speaking, that's not going to happen in criminal court. That is not what criminal court does. It is rare. Now, when you have the criminal case, one of the big things that happens is you can use what goes on in the criminal case as evidence in the civil case. And often you'll find, not always, you'll find that the criminal case moves faster than the civil case. Now, that's not always true, especially when somebody's connected, right? We've had some people who are a little bit connected in New York who really were able to slow down a criminal case for about 2 years, right? And you got to kind of hold the DA's office feet to the fire, and they don't like that. And it's, it's a lot of drama. It's the whole thing. But generally speaking, the criminal cases move faster than the civil cases. So you get to use what goes on in the criminal case as evidence, especially if your defendant in the civil case ends up taking a plea bargain in the criminal case, because often they'll plead guilty to something. And that's them admitting they did it. Now, this happens a whole bunch in workplace sexual harassment cases where there's forcible touching, right? A sexual assault, essentially, where you'll get the bad actor facing criminal charges and they'll end up pleading guilty to get out of further repercussions. And they have to swear on the record they have to swear they did it. They have to say they did it, right? Great. Good. That's amazing, because now we have that bad actor saying, yep, I did it. And we have this case against the employer, right? Because that generally the workplace discrimination, the workplace sexual harassment laws are against the employer, not the bad actor. So we say, listen, the guy you're saying is innocent, he says he did it. So you, employer, are liable for what he did. And he says he did it, so you're liable. So, here we go. They can still try to fight that, believe it or not. They can be like, oh, that's not what really happened, though. They can try. It's just a really tough uphill fight. Like, it's not going to work out great for them, generally speaking. And so what goes on in the criminal case can inform, can be used as evidence, can be useful for in the civil case, but it's not the same. And the criminal case is not going to make a plaintiff in a civil case whole. It might punish the person who did bad things, but generally speaking, it's not going to make the victim whole, right? And that's what the civil case is kind of about, paying some kind of restitution, which is also, frankly, not going to make the person whole, right? Like, dollars in a bank account do not make up for being attacked because of your membership in a protected class, or being assaulted because somebody's attracted to you, or they're trying to use their disparate power in a power disparity situation to force you into some kind of intimate contact, right? It's not going to make you whole, but it's an attempt to do so by putting dollars to it, right? It's an attempt to punish the employer also for not being more proactive and not having avoided, or at least responded correctly to, whatever bad things happen, right? So that's kind of the general notion of what's different between the civil and the criminal case. Now, it's possible for the attorneys representing a plaintiff in a civil case to have a good working relationship with the district attorney's office and to collaborate a fair amount. We have done that. We have gotten that to work. It doesn't always work. District attorneys are state employees, and some of them are amazing, but many of them are less than amazing. And, I always share my story. I used to know an ADA. I'd meet him for the 4:00 game on Sundays for football, during football season, at a bar. And he would order himself pitchers. There was a pitcher deal. He would order himself pitchers of beer, generally Guinness, and drink out of the pitcher as if it was his beer mug. And he would do that for the entirety of the 4:00 game. I'm not going to reveal where this was because I don't want to harm anyone. And he would do that for the entirety of a football game. So, about 4 hours. And then he would go across the street and do night court as an assistant district attorney. Are all assistant district attorneys like that? No. But it happens, and a lot of them, have their own failings, right? Whenever you're dealing with government employees who are attorneys, those tend to not be the best and brightest, right? Because it's hard. If you really think about it, it's hard. How are you going to be an attorney? Usually going to be carrying six figures of loan debt, if not more. I certainly have friends who owe like 300, 400K student loan debt. And you're going to go work for the state and make 60, 65, living in, even worse, New York, where rent's minimum probably $3,000, probably for a decent apartment closer to $5,000. I mean, if you want to live alone at least, right? If you don't want roommates, it gets a little pricey in New York. It's tough. It's tough to go make 65 doing that. Even if you really, really have a passion for criminal law and for justice, it's tough with all that student loan debt and that rent and everything else going on to go take the 65K to be an assistant ADA starting out. Sure, they can work their way up. They can stay for a decade and get to like 120, 140 maybe, but even then, to be in your late 30s, under all that loan debt and all that rent you got to pay, and you're making 120, 140, this is a hard decision. Often what you'll see is that the best and brightest do not make that decision. And so some of the ADAs that you get are perhaps the lower functioning group of folks who happen past the bar, right? So they're not always stellar. Now, listen, some that's not always true, right? There's some people who have a real passion for justice. They believe, they're true believers, they're going to right the wrongs, they're going to be Harvey Dent from Batman. No, he became evil, but he was good at first. That certainly happens. There's also people who like are going to be an ADA, they think they're going to get into politics or whatever. Like you have Alvin Bragg in Manhattan, who's kind of a questionable character in a variety of ways in terms of getting his job done. But he certainly thinks he's got political aspirations. He thinks that's going to be the launching pad for his political career, right? Like that's a thing. So that happens. Don't get me wrong. There can be, true believers who are truly, truly amazing who work as ADAs and district attorneys. It's just not the norm. So it can be hard to collaborate with them. And, it is really, truly two different worlds. Civil attorneys, in our field, in employment law, they need to win the case to make money, generally speaking. And that leads to very different behavior patterns. It leads to very different thought patterns in terms of how you approach your caseload. Realistically, ADAs don't particularly care if they win or lose. In fact, they'd prefer to not find out. They prefer to plea bargain almost everything, if not everything, because that's less work for them. They don't have to do trial, right? And trial is exhausting and brutal. It's hard, especially because their trials, it's often one or two of them, And I mean, listen, we bring a trial team, it's generally minimum of 3, right? So like extra pair of hands really lightens the load a little bit, So yeah, safety buddy, it is two completely different worlds. The things you need to prove for the civil case are not the things you need to prove for the criminal case. And proving the criminal case does not necessarily mean that you prove the civil case, or vice versa, right? They can both happen at the same time, and they can both be used to inform the other case, but they are really and truly different and worlds apart. And on this channel, I just do not have the depth of knowledge about criminal law to answer your questions about what might or might not be a crime. Also, frankly, if it's not a question of federal crime, I'm not even allowed to answer your questions about what might or might not be a crime in most jurisdictions, right? Because that's a state law, and I can't speak as to state law on this channel. I can speak as to the federal laws that pen through the Equal Employment Opportunity Commission and some state laws, depending on where we are, right? So that's my limitation. But yeah, it's just completely different worlds. Like not really all that connected, believe it or not. Anyways, safety buddy, I wish you great luck. I'm sorry that your pal is having trouble finding representation. I hope your pal can use the playlist that we have on how to pitch your case to employment attorneys. I hope that's effective for them. I wish you and your friend great luck in both the criminal and the civil case, and I will be cheering you on from over here. I have to tell everyone again to like, subscribe, comment down below, and apparently share. Sharing is caring and will help our channel to grow. And that'd be swell, right? Okay, everybody, take care.